Welcome to our Gevers Has You Covered video. Today we're going to focus on FAQs related to Brexit and U.S. trademark owners. And my name is Stephanie Shadroff, and I'm Head of Business Development for Gevers. And I'm really excited to be here today with Peter de Grauwe. He is a trademark attorney with Gevers, 14 years experience, and he has a special interest in Brexit, and especially eager to help U.S. trademark owners. So let's get started, Peter.
Well, that sounds great, Stephen. To those listening in, if there's any question in your mind that isn't answered here today, we're available for any Brexit consultations you may want.
So wonderful. Let's go with the first question we have. With the final transition day looming around the corner of December 31st, what is going to happen to EU registration?
Well, first of all, EU registrations will no longer cover the UK. So that's a very important aspect. However, the UK Trademark Office will create a UK clone for every registered EU registration. This clone will have the same priority date, it will have the same filing date, and it will also have the same registration date as the EU mother registration. This UK clone will be created automatically and without a cost for the trademark owner.
Okay. And what about pending EU application?
Well, for pending EU applications, the same thing goes on. So they will not cover the UK anymore. But in this case, the applicant will have a so-called sunrise period of 9 months after Brexit to confirm his or her application in the UK. So this clone will not be created automatically by the UK IPO, and the usual costs for a UK application will apply in this case.
Okay, well, what about design marks? Will there be something different in handling those?
Well, there is no difference between word marks and device marks. But talking about designs registered and applied for community designs, which is something similar to design patents in the US, will also be captured by a regime which is similar to EU trademarks. Therefore, UK design clones will also be created in those cases.
Okay. There's been some confusion about oppositions. So let's say I oppose a third party's EU application and the opposition is based on earlier UK rights. What will happen to the opposition?
Well, if your opposition against an EU application is based only on earlier UK rights, then the opposition will be concluded automatically. So, depending on your strategy, you may wish to introduce a new opposition in the UK against the UK clone of the applicants. So, if you or your client is currently in a similar situation, I advise to reach a settlement with the applicant before Brexit.
Okay, excellent. So here's a question regarding cloned marks. So if a trademark owner needs to prove use of a cloned mark, how is that managed?
Well, for cloned marks, as the brand new owner of a new UK clone, you can actually rely on the use of your mark in the EU in the past 5 years. So that means that if you have not used your mark in the UK previously, but you did sufficiently use it in other EU countries before Brexit, your new UK clone cannot immediately be invalidated for lack of use.
Okay, and what about after December 31st? If I need to prove use, how will my use be assessed?
Well, there's two things. First, with regard to the UK clone, gradually, as time passes, you will need to build up use in the UK as well to maintain your rights. And the opposite, secondly, is also true for your EU 27 mark. So if you have only used your EU mark in the UK before Brexit, you will gradually need to build up use in the EU 27 countries as well.
Okay. And again, like after the 31st of December, how will license agreements be interpreted?
Well, license agreements Well, it very much depends on the law that is applicable to your agreement, because the laws can be different in different territories. But in general, it will depend on the clarity of your contracts, the clarity about the territorial scope of it. So if any interpretation would be required in order to determine whether UK is included, yes or no, then the parties may wish to clarify this point and draft an amendment. Also, if the UK remains covered in your license agreement, as a licensor, you have to make sure that the UK, as a separate territory, maintains coverage, and so you would have to maintain these cloned UK rights as a licensor.
Okay. And what about some practical tips, related to Brexit? Do you recommend consolidating portfolios with the EU and UK, or what do you recommend?
Well, the UK will be seen as a separate IP territory, especially for trademarks and designs. So you will, as a trademark or design owner, you will need to appoint a local UK representative to take care of all the cloned rights and to administer these rights. So in any case, there will be additional management to be done. Now, the advantage, of course, of consolidating European work is to simplify your overseas IP work. And having a one-stop shop will allow you to have not only consistency in your communication, but also your local European partner will have a better understanding of your company or your client's activities and interests.
And then with respect to Gevers, are there special packages or actions that Gevers offering to help clients, ease the pain of all these changes?
Well, talking of pain, Brexit is indeed causing a lot of headaches to our clients, and Gevers wants to, well, first take away any concerns of our clients at IP level, but secondly also to mitigate the financial impact of Brexit as much as possible. We have historically partnerships with different UK firms, and in view of Brexit, we have chosen to further deepen those mutual relationships. And together with our UK partners, we have worked on a number of packages, including EU 27 plus UK filing packages and renewal packages. And we have deliberately chosen to keep our fees as low as possible in order to support our clients to maintain their UK clones and their UK coverage as much as possible.
Okay, well, thanks, Peter, and for answering all these FAQs. And as Peter mentioned before, we're happy to do consultations on Brexit. Peter is a team of 4 attorneys that focus specifically for the US, and they're available. You can just send me a message through LinkedIn, I'll coordinate it, or you can find my email address, Stephanie Shadroff, on the Gevers website. And also, please follow us on the Gevers LinkedIn page. We're doing Brexit posts weekly, about 2 a week, all the way through December 22nd. And so this concludes our Gevers Has You Covered video. So I'm saying bye-bye.
Bye-bye, everyone.
And thank you.